This is an appeal in the matter of Watson and MH Site Services Ltd and another.
Yes.
May it please your lordships, your ladyship, I appear on behalf of the appellants in this matter. My learned friend Mr Turner, to my right, appears on behalf of the respondent.
Yes.
I've had a very helpful indication from your clerk yesterday that the core bundle has been carefully read.
Yeah, the court bundle's been carefully read, at least some, not all, but some of the authorities. Subject to anything that you might say, our view is that the most efficient way of dealing with this is for you to deal with the jurisdiction point, and then Mr Turner can respond to that and make his points under the respondent's notice, including the academic appeal point, and then you can reply on the jurisdiction, respond on those other points, and then if there's any reply from Mr Turner on the respondent's notice points, he can do that. And that way we can at least focus on the jurisdiction point, which is the point that obviously is the one for which permission to bring a second appeal has been granted.
I'm very grateful, my lord. Just before I start, just to check, there was one omission from the core bundle,
yes,
which was brought over yesterday to court. Those who instruct me apologise.
The judgment of DJ Baldwin.
Indeed.
Yeah, we got that. I had that. I had that separately.
I'm grateful it's been inserted at page 183A. By way of explanation, I think what happened is originally only the judgment was obtained for the permission before His Honour Judge Wood, and then His Honour Judge Wood made an order that he wanted a transcript of the whole hearing, and that's what's made it into the appeal bundle, but that whole hearing transcript omitted the judgment part, but now you have both.
Okay.
My lord, we've set out a fairly extensive written argument on the substantive appeal, and I don't think it would assist necessary for me to simply rehearse that. What I would propose to do is perhaps deal with the points that are made in my learned friend's skeleton and respond to those and answer those points, and also take any specific questions on the written argument that I've provided in my skeleton argument on behalf of the appellant, if the court is happy with that.
Yes, just before you do that, can we be clear, what is it that you actually want?
In terms of the substantive appeal, the appellant's notice seeks the order of District Judge Baldwin to be set aside to essentially, so it no longer exists, because it was the reasoning that led to that order that we say was wrong and that is problematic.
Does that mean there'd be an undetermined application before the court? The one that he dealt with?
There could be potentially, but I suppose that could be dealt with by way of a withdrawal of that application.
Or no order.
Or no order on the application. The problem is the order as it reads is the application is dismissed, and it's the reasoning that led him to that dismissal that we say is problematic.
So you don't ask the court to make the order that you asked the district judge to make at that stage in relation to the settlement package?
No, because I don't. I would concede. I don't think that order can be made now, because the matter was subsequently removed from stage 2 of the stage one of the protocol. So it never actually got to stage 2. And under paragraph 511 of the protocol, as set out, I think in both skeleton arguments, it's not controversial between us that once a claim exits the protocol, it can't re-enter.
So it's academic.
In those very strict terms, as between Mr. Watson and MH Site Services Ltd. But as I've said, obviously, in both the submissions in response to the point being raised in the respondent's notice and in the most recent supplemental skeleton, we've made the point that it isn't academic as between the wider parties. There's another appellant here who is a nationwide insurer.
Because it does give rise to a sort of related point that appeals are against an order rather than the reasoning of an order. So District Judge Baldwin may have been wrong to say he didn't have the jurisdiction, let's say, but he may have been right to make the order that he did.
Well, that's the appellants have never sought to argue that had he directed himself correctly, he would have had a discretion. Where he fell into error, we say, is that he simply directed himself that he had no power whatsoever. So he never got to that.
I understand that, but you see the point that I'm making, that I mean, he might have decided that because the stay only had 3 months to run anyway, and because the order that you sought was too draconian, let's say, he might have concluded, well, I'm not going to allow this application. I'll let the stay run on for another 3 months, and in that time, see if the claimant complies with the protocol.
Yes.
So he could have, that's all I'm exploring, he could have made that order for different reasons.
Yes. Yeah, I can see that, and it's always been conceded by the appellants that if you're with us that he was wrong to find that there was no power, that there would be a discretionary power. And the way in which we would see the applications working is that in response to such an application, a claimant would ordinarily put in evidence in response to perhaps try and explain the chronology of what's been going on and how much longer is needed. And a district judge weighing up that evidence, as they do in all manner of applications exercising their discretion, would take that into account. And it may not be 21 days. I mean, you'll note from the original application notice, 21 days is in square brackets. The judge could have decided 21 days, 42 days, 3 months, 6 months. But all of those are discretionary exercises of discretion. And as I say, to come back to the problem that we had here is that District Judge Baldwin found he had no discretion. It was simply...
Yeah.
The short point is surely that we don't know how the district judge would have exercised his discretion had he thought he had one. In fact, he didn't think he had one, he ruled that he didn't. And I think that although my lord is absolutely right, of course, that appeals are usually against orders, that position very much depends on orders rather than reasons. There may be rulings on the step to the order which are also challengeable, and there's quite a lot of case law on that.
Thank you, my lady.
So as far as the jurisdiction point is concerned, speaking for myself, I don't think that is an inhibition to our determining the jurisdiction point, because it was a step on the way to the order that was made, and if it was a wrong ruling in law, then I think that is open to challenge.
That's certainly our case.
Yeah. So anyway, that's your point. So yes, so you were going to you take your skeletons on the jurisdiction point as read, and you say you were going to answer the points raised by the respondent.
Yes, and my lord, would it assist to deal, obviously, at front and centre of Miller and Friends' argument is that this appeal is academic, so would you like me to address that now as I go through the skeleton, or do that separately?
Address which, sorry?
The point that it's academic, because that's front and
No,
centre.
I think that effectively arises out of the, I mean, it's a separate point. It's a defensive point raised by the respondents. So put that to one side. We'll get Mr. Turner to deal with that because it's his point, and you can respond to that. So it's the jurisdiction point.
I'm grateful. In which case...
I'm sorry to be a little slow. I just want to make sure I've understood what's before the court. I asked about the second limb of your application before the district judge, namely to require to impose a sanction effectively if within 21 days the settlement package wasn't provided. I think the district judge asked the same question. As I understand it, before him, the two limbs stood or fell together. You weren't asking him to deal with them separately.
Yes, my lord, and that's explained.
And that was confirmed, I think, before the county court judge as well.
It was. I can take you to.
That's all I need to understand.
And I can explain why, if it would assist, my lord. The reason why the application is framed in the way in which it was is because of, in fact, the case that my learned friend cited of Grant in his response to the appellant's notice in this court, is that what we recognise that whilst the claim was stayed, that was a procedural bar for there being any case management directions behind that stay. So the reason why paragraph 1 is there is to remove the stay to allow the court to then actually make a case management direction, because otherwise the stay could conceivably operate to prevent the date for that, for example, actually running.
Yes.
That was why paragraph 1.
But if, on the other hand, a judge had thought the second limb wasn't justified, there'd be no justification for interfering, for changing the stay. They stood or fell together.
Well, they stood or fell together in this case because District Judge Baldwin indicated that well, first of all, he indicated that he wasn't going to make the order that we wanted on paragraph 2, and then asked me the question, do you still want me to deal with paragraph 1, and indicated that the only power he felt he had under paragraph 1 would be to transfer to part 7, which we didn't want, and we didn't want that for primarily cost reasons, which is identified, I think, by either Judge Baldwin or His Honour Judge Wood, where they say, I think it's Judge Baldwin says that the defendant doesn't want to expose themselves to the jeopardy of that cost at this stage. And we didn't, because if it had gone to part 7, it would have removed it from the very restricted protocol costs that existed. So we were sort of backed into a corner, if I put it that way, that we said...
Well, I mean, the district judge gave you the choice, and you said no. I think there was some debate about having some costs order attached to it, and I think DJ Baldwin said not unreasonably he couldn't make that order because he couldn't make the costs point until the end of the case. So you said no, well then you didn't want the stay to part 7.
I mean, it did descend, that wasn't our application, I did say that to Judge Baldwin. We never sought a 4524, now 4535 order. That didn't form part of our application, and there are very different considerations and criteria under that rule that is outside the scope of this appeal that would have had to be met, one of which is that a judgment needs to be entered to engage it.
Exactly.
Secondly, that the court then needs to find that the claimant under paragraph 2 has acted unreasonably in either not using the protocol at all or valuing the claim in excess of $25,000 when it was unreasonable to do so, or acting in any other way that caused the protocol process to be discontinued. And it would be that limb that we would have relied upon, but of course, that really wasn't what was before Judge Baldwin. That wasn't our application.
No, but the lifting of the stay, your application was to lift the stay for the very specific purpose of the directions that you sought in relation to the pre-action protocol process. But in a normal case, when you lift a stay, when there's a protective proceedings under Part 8, you lift the stay in order to transfer it to Part 7.
Yes, or to commence the Stage 3 procedure.
Yes, yes, but that is usually, if it's not settled under Stage 2, it's usually a full-blown dispute, so it needs to be transferred to Part 7.
It goes to Part 7 if the protocol process is discontinued, which could be on complexity or value, because it can't then be resolved in Part 8. But if it went through Stage 2, through the settlement consideration period, and both parties made their final offers and it didn't settle, paragraph 16 that you've been referred to, the practice direction, then allows the claimant to convert their stay Part 8 claim form, if I put it that way, into the Part 8 process that deals with Stage 3.
Yeah, where there's a more limited amount in dispute.
Yes. I mean, it goes for either a hearing on the papers or a half-an-hour hearing before a district judge who hears submissions and rules, and then they open the envelopes at the end.
Yeah.
And if the claimant's beaten their offer, X happens, and if the defendant's beaten their offer, Y happens.
Thank you. Right.
If I pick up the respondent skeleton then at page 76 of the core bundle, and the first point that's made at paragraph 8.
Page 30.
Page 78 of the,
Oh, 78.
of the core bundle, paragraph 8.
Yeah.
So the first point that is made by my learned friend is that this order would have required the claimant to place monetary values against his claim, but also to disclose privileged medical evidence. It's an order compelling that. I accept the court has no power to make an order to compel a party to disclose a unilaterally privileged document. But that is not what this order did or sought. This order is a conditional order, like many orders that the court makes, and that's the only reason Edwards Tub appears in your authorities bundle. I don't think the principle is controversial between us, that the court does have the power to say, for example, in Edwards Tub, if you would like to rely upon a second opinion of a different medical expert, the condition for that permission is that you must disclose the report of the first medical expert that you obtained. So it isn't directly order, can't do that, but can make it a condition. And we say this is simply a conditional order. What this order is saying, the nub of this order, if you put it in its context, and that means you need to remember what the Part 8 claim is for. The Part 8 claim is unique in this situation, as my Lord said in Cable, to these processes. It is granted solely and exclusively for the purposes of granting a stay to protect the claimant's position in respect of limitation whilst they continue to comply with the protocol. That's its purpose, only purpose. And what this order seeks to do, in effect, is to say to the claimant, if you are not going to use this stay for the sole purpose that it has been granted for, i.e. progressing the claim through the protocol, by X date, then you will lose the benefit of the Part 8 stay. It's a conditional order. So the ball is then firmly in the claimant's court as to whether or not they comply with that order or not. And there will be litigation decisions and tactical decisions made about that, but ultimately the court is putting a date on it to say, you've had the stay for this amount of time. This is how much longer you've got. It's a matter for you as to whether or not you comply with that. And if at this point
the point in paragraph 10 is a temporal point. It would have compelled the respondent to disclose a privileged draft medical report. I mean, that's because that's all they had at the time.
Yes, but it wouldn't have compelled them to do that. It's a matter for them if they wanted to finalise it and disclose it. But of course, again, these applications you put in their context, they're many years after the accident. The court is looking at a case that the claimant has already had a long time to get to this point. And it comes back to that discretionary, how good is the explanation? If it's a very poor explanation, the court might say, well, you're only having another month. If you can't comply in a month, then it's a matter for you. You're going to have to adopt a different strategy to your claim, which will probably be an application to transfer to Part 7, which then would engage the protection for the defendant under 4535. But it's the claimant doing that then. It's the claimant removing it, not the defendant. That's why it's important that it happens in that way, because you won't get 4535 protection if the defendant removes it, because clearly paragraph 2 of 4535 says the claimant's unreasonable removal. It may be at this...
Just catching up again. The order you sought would have allowed 21 days for compliance, failing which the claim, the Part 8 claim, would have been struck out without further order.
Yes.
So what would have happened if that had come about? What would have happened?
So what would have happened? Well, the Part 8 claim, those proceedings with the stay would have come to an end.
And they were only there in order to prevent the claim from being statute barred.
Statute barred, yeah.
So the claim would have been statute barred.
it would have been a matter for the claimant to reissue the claim via Part 7 and then seek discretionary relief under Section 33. And a matter for the defendant also as to whether they raise a limitation defence, because of course, I mean, it's still liability admitted. I mean, it depends how long it's been stayed for. That would be a factor that may weigh in that balance. Some of these cases have been stayed for 2, 3, 4, 5, unfortunately in some 6, 7 years.
Thank you.
It may be worthwhile just to pick up on a point I was going to make later, but it neatly fits in now as to what we see as the beneficial effects of these applications for these conditional orders. So we see there are 4. And again, put this in the context of what usually happens is, or even more context, the protocols are designed for the swift resolution of low-value claims at proportionate cost without the need for court proceedings, usually with a single medical report. By the time we get to this stage, those aims are clearly not being met because, 1, it's been persisting for 3 years, 2, court proceedings have been necessitated. Ordinarily then, that's when it goes to the solicitors. There's going to be some time thereafter where the solicitors are chasing and seeking updates and are usually met with either complete silence or no or proper substantive updates as to the progress. So this application is then made. What effect will that have? Well, 1, in certain cases, for example, where the claim is actually no longer being prosecuted, it will lead to an order, the court will make an order in probably short terms, maybe 21 days. It won't be complied with. The Part 8 claim is dealt with. Scenario 2, claimant solicitors sit up. There's now an application before the court. The court's going to consider our compliance with the protocol. We need to investigate and provide an explanation as to where we are. They will sit up and take action, wake up. They may provide a very good explanation to the defendant and completely reassure the defendant that the claim remains at all times suitable for the protocol. And in fact, it won't be much longer until they can get it to stage 2. Application potentially compromised, no need to trouble the court. Third case, maybe they provide evidence to the court. It does go to an application. The district judge assesses that evidence, the explanation and the chronology, and then fixes a date by which that stay has to be used by, achieving the progress that is sought in the case. So as I say, it is not an order compelling. It's simply an order putting a condition upon that compliance. And it's a matter for the claimant then. I mean, say the court gave 3 months. And again...
Not an order compelling.
It's not an order compelling them to disclose medical evidence.
But your order was, because your order was, unless by X they submit, the claim shall be struck out.
Yes, that was loose of me. The order compels them for a stage 2 pack.
Yeah.
But it doesn't, my point is that of itself then compels them to disclose privileged medical evidence, which it doesn't. Because it's a matter for them as to whether or not they disclose it or not. What the court is doing is saying, for example, you have, if we said 3 months, to get all of your medical evidence in order and get this case to stage 2. And if you can't, then as I say, you'll have to adopt a different strategy to your litigation in the context of a claim that's been already proceeding for in excess of 3 years. Over the page to 77, oh sorry, one last point on the paragraphs 9 and 10 that my lord you referred to. No, over the page to paragraph 11, page 77. I must admit I'm not entirely sure where my learned friend is going with this argument surrounding Churchill, and I'm not sure, when I've looked at Churchill, which paragraphs are marked up, but this seems to be directed at staying proceedings to compel parties to engage in ADR, which has never been our position, so I don't respond to that. And the final points at D and E, I say, contradict each other. Because again, it's saying that an order would compel the claimant to prematurely disclose a privileged draft medical report. But then underneath it says to force a claimant to enter settlement negotiations before being in possession of a finalised medical report. and you can't go to stage 2, if you look at over the page on 76, without a medical report. So this reference to the Civil Liability Bill is misguided, because you can't do stage 2 without a finalised medical report. So no one can make this point that somehow that it's inviting parties to settle without medical evidence. It simply can't comply with stage 2 without a finalised medical report. So there's nothing in that point.
Yeah. I mean, the simple point is you wanted them to comply with stage 2 with all the various bits of stage 2 or the settlement pack that is necessitated under stage 2. And you don't have stage 3 unless you've complied with stage 2.
That's exactly it.
And the whole purpose of the issuing protective proceedings under Part 8 is to protect a party who is endeavouring to comply with the protocol, and therefore endeavouring to produce, in this instance, a stage 2 settlement pack.
It was twofold in my submission. It was also, this practice direction was also created to stop the mischief of claimants simply waiting to limitation and then issuing Part 7 on that basis, to take it out of that very prescriptive cost regime. That's why this procedure's there, because otherwise you could just wait to 3 years and say, well, I have to issue Part 7 now, so it has to come out of the protocol, and then you go into a more advantageous cost regime. So this procedure means that doesn't happen.
Right. Sorry, this procedure being?
The Part 8, the modified Part 8 procedure, which allows the stay.
So the modified Part 8 procedure is designed to prevent the claimant waiting 3 years and then issuing Part 7 proceedings.
Yes, because all claims could be left to limitation, and then it would be a justification to take it out of the protocol, because it couldn't continue without a limitation defence potentially. Well, the next point taken on page 78 is that there's no power to compel compliance with stage 2 of the pre-action protocol generally.
Mm-hmm.
And I say paragraphs 12 and 13, in my submission, essentially concede this appeal. Because, well, they essentially, when they're read,
Sorry, paragraphs
12 and 13 on page 78, because my learned friend first of all accepts that it's not disputed that the pre-action protocols are fully integrated into the framework of civil justice. And in paragraph 13, goes on to say it's not in dispute that once Part 8 proceedings have been issued pursuant to Practice Direction 49, the court has the power to case manage those proceedings. Yeah. And that's what we say.
Yeah, the protocol is not part of these of the Part 8 proceedings. It predates them.
But it's expressly, it's inevitably, and to adopt my Lord's wording in the case of Cable, if I take you to it, in the authorities bundle at firstly page 12, paragraph 54 of Cable.
What's the word?
At paragraph 54 in Cable on page 12 of the authorities bundle, my Lord said, it is not always possible to distinguish neatly between the conduct of an RTA protocol process on the one hand and the conduct of any parallel court proceedings on the other. And then over the page to page 13 and paragraph 59, bottom of page 12, first paragraph 58. It would be counterintuitive if non-compliance with those rules could be dismissed as being irrelevant to the court's overall control of civil business, including the ability to strike out for abuse of process, simply because they related to a period before the formal commencement of court proceedings. And then at paragraph 59, perhaps I say the most crucial citation. In addition, of course, Practice Direction 8B is expressly referable to these low-value PAPs. So I come back to the point, the Part 8 proceedings are only there because of the protocol. So it's inevitable that they will have reference to it. There's nothing else for them to have reference to.
So if we take it in stages, you would accept that in general terms, absent the Part 8 claim, the court doesn't have the power to make orders in relation to the PAT process.
No. Right. So the court couldn't reach into that as a standalone application, for example. This is about managing that stay. Part 8.
So it's only the issue of the Part 8 claim that opens up the possibility of the court having jurisdiction.
Yes, because as I've said in my skeleton, once there are extant Part 8 proceedings, which is what the claim form, the Part 8 claim form does, there must be then a power to case manage them.
To manage the Part 8 proceedings?
The Part 8 proceedings, which inevitably will have reference to the protocol, because, as I say, that's the only reason they exist. But the order that we sought didn't seek to enter into the protocol itself or make any direction within that protocol itself.
And the point that is being made in paragraph 13 of the respondent skeleton is this is what the Deputy District Judge was doing in the previous year when he made it, I think it's in 2022, that order from memory, reflecting the options available under paragraph 16.5 and 16.7 of the practice direction. I mean, the order that he made was an order that the Part 8 claim be struck out after a year, unless either the parties have proceeded to stage 3, I beg your pardon, or there'd been an application to transfer into Part 7.
And my lord might see some remarkable similarities.
But the first part of that, the first of those two alternatives relates to the protocol process. I think that's the point that you're making.
Well, there's 3 points. 1, it's an unless order.
Yeah.
Same. 2, it's a conditional order.
Yeah.
Same. 3, it provides a date for compliance. Same. 4, expressly refers to the protocol. Same.
In the first limb, yeah. So what was happening here on this analysis is that you asked for an order of a similar structure, but rather more specific or detailed in relation to the settlement package.
Indeed.
Rather than going to the end of the PAT process, it was dealing with one component stage along the way. Is that the way to understand your submission?
In a way, yes, my lord, because the point is made, obviously you can't comply with stage 3 or that order without going through stage 2.
Yes.
So indirectly.
But it was drilling down into an earlier part of going on the way to complete stage 3.
If it would assist, my lord, I was going to address this point later when I come to one of the friend's arguments that this order isn't required. That the reason why this is different to the order that Deputy District Judge Openshaw made is that the stay and the unless order that Deputy District Judge Openshaw made referred to stage 3. To get to stage 3, you have to go through stage 2. But built into the protocol is mandatory time periods at stage 2 for consideration of offers and negotiation. So if you approached it on the basis that stage 3 is your red line for compliance, you'd have to build in sufficient period of stay to allow the stage 2 process to be undertaken. So I had a similar case to this where I think it's about 49 days in total. And then from that, you've got to build back how much longer you want to allow for a stage 2 pack. And only if the claimant then submits the stage 2 pack by the theoretical date, which isn't in the order, in this order, can they actually comply. Because if they don't submit the stage 2 pack, they don't have enough time to do the consideration period and the negotiation period. What this order does is focuses it on that next stage of stage 2 by saying the stage 2 pack needs to be done by this date, and then everything else flows time.
I mean, your order?
Yes, what we were seeking.
Proposal.
Focuses it on that next procedural step of stage 2.
Yeah, yeah.
Is one of the reasons why I say my learned friend's argument. There are other reasons which I'll come back to, but that is one of the principal ones of the difference.
Well, you're saying by implication it is managing part of the PAT process. the earlier order.
Well, I say the earlier order is evidence that the court has the power to make the order I'm seeking.
Yes.
Otherwise, what we don't accept is you could have that order is permissible. But what
It's not doing it directly, but it's doing it as a condition of the imposition of the stay.
And that's exactly what we sought, I say. It's condition. If you want to maintain your stay, then you must do this by this date, which is all that Deputy District Judge's Openshaw's order did.
Just to tidy up the loose ends, I mean, the order he made was at a point before PD 49F existed, as I understand it. So his order refers to PD 8B.
Yeah. So the rules...
Are they materially different? No.
So the original modified practice direction to Part 8 was Part 8B, which essentially contains what is now in the practice direction to 49F. The provisions, as I understand it, were the same. It was just moved as part of the changes that came in, I think, to the general fixed cost regime in October 2023, I think.
So Cable talks about practice direction 8, whatever it is. 8F, is it?
8B.
8B, sorry. And that is, your researchers show that's the same as 49F.
49F, yeah.
But when, under his order, which is at page 203 of the bundle, the first limb was the plus should proceed to a stage 3 hearing pursuant to 8 PD 8B, now 49F. Would that have been a hearing in the Part 8 claim?
Yes.
Yes, which is what you were submitting earlier on.
Yeah, if it would assist, my lord. So there are 3 stages to the protocol. Stage 1 is liability, and I think the insurer has a very short period of time, maybe 15 business days, to either accept the claim or not. If they accept
Stage 1 is ticked here because
Yep.
it was admission of liability. Yeah.
So then goes to stage 2, which is when supposedly quantum is supposed to be swiftly resolved. That involves the disclosure of the medical report they've obtained and any evidence in respect to special damages, and the stage 2 pack's at the back of the bundle. Actually, it shows essentially they upload figures that they say this is how much my claim is worth. The insurer gets to look at it, either accepts it or says no, this is what I say it's worth. There's a negotiation period, and the claim either settles or they both make final offers. If it's before limitation, the claimant then is required to use Part 8B to issue a Part 8 claim form to go to stage 3, which is a 30-minute or so hearing or a decision on the papers by a district judge to assess quantum, then open those 2 offers, as I said earlier, to see whether or not anyone's beaten offers, and that has limited cost consequences. It's all very low and controlled. The other part 8B, is when limitation arises, which is the scenario we have here. If the claimant does comply with stage 2 while it's stayed, but settlement isn't reached, it's just the same process I outlined, but the Part 8 form is converted to the stage 3 claim form, and then it proceeds to a stage 3 hearing. Or alternatively, as my lord identified earlier, and what happened in Cable is, if the claim is in fact not suitable for the protocol, it goes over to Part 7. And this is one of the other mischiefs that this application is aimed at, is flushing out claims that are persisting under prolonged periods of stay that aren't in fact suitable for the protocol.
Where, for example, you've got a tricky causation argument.
And from experience, a lot of the cases are that are flushed out. And they've been sat there for 2 or 3 years, and all of a sudden it then needs to be started in Part 7. These applications generally deal with that because it makes the claimant solicitors sit up and face what's in front of them and make a decision.
Okay.
So on to page 79. One of the friend argues that both District Judge Baldwin and His Honour Judge Wood KC were right to conclude that no power existed. So point A, he says that stage 2 of the protocol concerns pre-action conduct. Insofar as that board decision is made, it's right, but once, as we've already gone over, once the Part 8 claim form is issued, it's no longer pre-issued. It's an issued claim form, over which I say the court has case management powers. Point B is that if there was an intention for this sort of application, it would have been expressly provided for. And my answer to that is Not necessarily, because I come back to what are the aims of the protocol. It's likely that this scenario would not have been envisaged. The reality is, it should be, in my submission, quite a rare event that any of these claims reach 3 years and limitation if the aims of the protocol are being met. But as we know from the comments of both His Honour Judge Wood and District Judge Baldwin in this court centre alone, this is a very, very common occurrence. And there are claims that are stayed not just for 12 months, but are then repeatedly stayed thereafter. All of that runs contrary, I say, to the aims of the protocol, and the court should have some mechanism by which it can encourage compliance with the protocol.
But only if a Part 8 claim's been
But only
issued.
if. That's only when the problem arises. I mean, it's got to be put in its context, as it was in Cable. The abuse was put in context in Cable. It happened in the 3 years of the limitation period.
Yeah.
These problems only arise once it goes into Part 8B.
This case is about the court's power or jurisdiction to make an unless order, where the unless order actually relates to a stage in the PAT process. If there is such a power, would the court also have a jurisdiction to do something less extreme and make an unless order, and simply to direct that a particular stage in the PAT process be completed by a particular date?
Well, logically and necessarily so.
Yeah, but presumably, as a matter of practice, that should be discouraged.
Yes, because
we shouldn't end up with micromanagement of the PAT process by directions from judges.
I mean, in reality, my lord, what's mooted there would in fact not really...
Just to pursue that a little further, sorry to interrupt,
Yeah.
but there's a jurisdictional question, and then there's a merits question. But by definition, an unless order is a fairly extreme measure, isn't it?
It is, my lord.
So it wouldn't be reached unless there was sufficient justification for it, going beyond the normal justification for making an ordinary direction.
I would agree, but of course in these cases the justification for it is the conduct and the delay that has got us to the point where this application has been necessitated, and if found by the court to be well founded, will inevitably, in my submission, lead to finding that there has been poor conduct and poor progression of the case on the part of the claimant. The second point is, if it wasn't with an unless order, I'm not sure that would in fact really solve the problem.
It would have no teeth.
Because it would, the other problem that I'm going to come on to about the order of Judge Openshaw is that it allows extensions. So if there's no sanction in that unless order, then the claimant could simply say, well, I come before the court on the initial application, say, oh, I need 3 months. Right, well, I'm going to say 3 months. And then after 2 months and 27 days, make another application to extend time to get it to stage 2. When what we're trying to achieve here is essentially finality of...
Not sure I follow that. Under the order that you were seeking, there could have been an application for an extension of time, couldn't there? It was an unless order in structure, but that wouldn't preclude extending time subsequently, really.
In exceptional circumstances, probably not, but I think if the court has put that red line down,
Yeah.
I mean, it could be in combination, there could be a recital to the order as well that would say that, the court's not going to grant any further stays in this matter.
Trouble is, you can't bind the hands of the court that way, because all sorts of things can happen. Somebody can become ill, caseworker. There could be all sorts of exceptional circumstances that mean that it would be unjust to grant to adhere to the unless order, and a short extension might be appropriate. Simply doesn't know.
As I said, Melody, I suppose you could hypothetically, in an exceptional case, see that the claimant, having had a history of poor conduct within, let's say, that 3-month period, excels themselves and gets so close to getting it to stage 2, but needs another 7 days.
Yeah.
Remember that the insurer is coming at this, that all they want to do is resolve the claim in stage 2. The insurer wants this case to be resolved in the protocol. That's where the fixed costs are. The problem is when it drags on for many, many years, is that 1, it's reserved, but 2, is the increasing angst that is this case actually suitable for the protocol when it gets to 3, 4, 5 years.
Well, it then becomes a stale claim anyway, because they're using the protocol as a means of putting off the limitation period. I mean, you've got protection. You get protected against a time bar, striking it out, then you spin it out for another few years, and
it's precisely one of the issues.
Purpose, yeah.
So you would hope that a reasonable defendant, if they were faced with that hypothetical factual scenario that the claimant needed another 7 or 14 days, would simply say, we can agree that, because, as I say, the insurer, if you look at the much wider picture, it doesn't actually potentially benefit the insurer if it's struck out, because if the claimant reissues it Part 7, yes, we can have an argument about limitation, but we've still got to deal with the claim, have that argument about limitation, have another argument about costs, whether it should be fixed to the protocol. If we can get it resolved in stage 2, that's the ideal. That's what we want.
Yeah.
We simply want the protocol to be followed. And when it's followed, it works. The next point on 79 is that somehow our argument is weak because we've had to fall back on the general provision in CPR 3.12M, and I simply reject that. I mean, that's included in the rules for good reason. And I say that doesn't necessarily undermine our point that that's the provision that we've chosen. The question in this appeal is, does the power exist or not? We say it does, and there it is. That's the rule that allows you to do it. I think we've been over paragraph D already. This issue of we're making an order within the protocol, and I think I've said quite a lot on that, and I've also taken you to the dicta that I rely upon in cable. The point is that it's expressly referable. You can't make an order in those Part 8 proceedings that doesn't in some way affect the protocol, because that's the only reason that stay exists. And then the phrase used is obliging a party to take immediate steps within a protocol on pain of losing their extant action inevitably engages with the protocol. But no one's saying it has to be immediate. I'm saying it's a discretionary decision. Yes, 21 days is sought in the application, but that's in brackets. It's a discretionary decision. The judge could say a month, 2 months, 3 months, depending on the evidence. So it would only be on immediate pain of losing their extant action if the evidence before the court justified that. Over the page to subparagraph E, this is a response to, I think, the point that was made in my skeleton that the impact of the order sought, or the order within the case management orders within the Part 8 proceedings, don't actually have any direct impact on the protocol itself. So whether or not this claim is struck out, or whether or not it stayed in the first place.
I don't quite understand that. Why?
So whether or not it's struck out, or whether or not it stayed in the first place, has no effect on whether it is in the protocol or not.
But if you'd got an unless order that they provide a settlement pack within 21 days, and they complied with that order, that would have had a direct effect on the protocol process.
It would have been expressly referable, yes.
So I mean, I don't understand where this point goes.
So if the claim is struck out, it's still in the protocol. So the protocol is an online system, and it only comes out of the protocol if one or other party presses a button or serves notice within that protocol to remove it. So the protocol action would still subsist with or without the Part 8 claim form. So the point is made in my skeleton.
But if the claim in the protocol process, say the Part 8 claim was struck out, the claim in the protocol process would then be a dead duck, because the insurers could sit on their hands. It would eventually come out of stage 2, and the claimant would endeavour to commence proceedings, but would be immediately faced with the fact that it was statute barred.
Potentially, yes. So if we take it in stages, if it was struck out, all that's lost is the Part 8 claim form. So the claimant could still...
But the Part 8 claim had been issued to protect the position on liability. It was the last gasp thing. So if that's gone, everything else is academic.
Well, they'd have to go via Part 7 and seek Section 33 relief. That's their sanction for the non-compliance with the protocol.
Well, I follow that, but I mean, it's all a bit unrealistic.
Yes, I wasn't putting it forward as an ideal solution for the claimant. I was putting it forward to try and emphasise that it doesn't actually impact on the protocol process itself.
Well, technically not, but perhaps, but substantively yes, because if they complied with the order, then it would, because they would have produced a stage 2 settlement pack. And if they didn't, although the claim might proceed academically in the PAP, it's not going to do anybody any good because it's a dead duck.
Depending on the insurer's response to it, yes. Because if let's say, for example, it was struck out, but then the claimant did upload a stage 2 pack for £5,000, the insurer then faces a decision. Either we settle the claim for £5,000 or we take our chances on it going to Part 7. We drop it out and say, haha, we have a limitation defence. You can go via Part 7, or their strategy is and if they ignore it, it will drop out automatically because of the time limit. And the ball's back in the claimant's court as to how they seek to progress it. I'm not putting that forward as a likely outcome, or indeed a preferable outcome, or a way around it, simply to make the point. And the other point I make in the skeleton is, let's just say, for whatever reason, the claimant issued a Part A claim form for a stay only 18 months into the limitation period. The court could look at that and go, no, it doesn't need that. I'm striking it out. It's still in the protocol.
Well, I understand that point.
Still proceeding the protocol up to limitation, could ask for another Part A claim form. And that's the difference, I say. And then finally, at paragraph 15, my learned friend said it's a radical step for the court to find this power. I say it's logical, proportionate, and an appropriate step in a particular case. Then we turn to the argument about existing routes which achieve the appellant's aim. We've covered quite a lot of this ground already. But I have two further points to make. Firstly, it's suggested that we should have availed ourselves of the 7-day provision within Deputy District Judge Openshaw's order to set aside the stay that was granted. And it said at paragraph 19, if the appellant felt a stay was unjustified in light of lack of progress, then we could apply to set it aside. But again, let's put this in its proper context. So, at limitation, it's issued via Part 8b. It's usually at that point that the solicitors are instructed on the defendant's side, and scrutiny begins to build as to what is happening on the claimant's side. They're not going to know within the first 7 days as to whether or not the stay is justified or not. What usually happens is there then follows weeks, if not months, of correspondence from the defendant's side seeking updates from the claimant. So is this claim still worth less than £25,000? Is this claim still suitable for the protocol? When will you be in what medical evidence have you obtained? When will you be in a position to disclose it? When will you be in a position to get to stage 2? And it's only once those reasonable requests made over a reasonable period are left unanswered that the application is made. So it's not going to be 7 days after the issue of proceedings.
No.
The second point, I follow that, because I appreciate you're saying the solicitors won't have been involved during the PAP process up until that stage, but the insurers would have been involved.
They may have written, but it only starts to become a big problem at limitation.
There will be an insurance claim, and they will know whether anything's happened or not. If something has happened, what has been going on.
And that will...
And the whole suppositions, foundation for this argument is the insurers are keen to resolve matters through the PAP process. So presumably they will have been, by definition, your argument assumes they will have been proactive. So I don't see why you need substantially more than 7 days to say there's been an abusive process, for example. as in the cable case.
Well, breaking that down, my lord, I mean, it may inform what the defendant's solicitors do after the issue of the Part 8 claim form. So if the insurers have been proactive, I mean, they're not going to be starting chasing these things immediately after it moves to stage 2. It might be, well, there may have been some updates provided to a certain point, and then it goes quiet.
When is stage 2 supposed to start?
Well, this is the issue with the protocol. Whilst there's a time limit after stage 2 to go to stage 3 if it fails, there is no time limit on stage 2.
But it can happen at any stage after stage 1.
Well, well, actually, that's not entirely correct. Once the claimant approves the final medical report, they have 15 days to start stage 2. But of course, until the claimant approves the final medical report, there's nothing that pushes it. So if they haven't got the medical report, then as was the case in, I think, in this case, it was still in draft form, for example, that wouldn't start. And it would only be the final one. So if the expert is a GP and says you need an orthopaedic surgeon, etc., it would keep going. The next point is coming back slightly to an issue that we touched on about simply varying the date for compliance with Deputy District Judge Openshaw's order. My learned friend says in his footnote that an insurer in that position would have to explain its change of position and possibly make an application for relief from sanction. The application could nevertheless be made. So that's a relief from sanction for not doing it within the 7-day period. But if we extend Judge Baldwin's logic, no power. No power. The only power I have is to lift the stay and transfer it to Part 7. I don't have a power here to case manage in the sense of considering applications for relief from sanction.
Why not?
Because that's what his decision was. The only power I have here in terms of case management is to lift the stay and transfer to Part 7. That's what he said. That's what I suspect you would be met with.
Well,
whether or not that's right is obviously contrary to what we say, because we say there is a case management power, and I think my Lord's reaction to that submission perhaps...
Well, you're agreed, because that's what paragraph 20 says. So Mr. Turner and you agree that you could have applied to vary the date in DJ Openshaw's order.
Yes, it's a case management power. We say.
Pardon?
Yes, it's a case management power. It's the point that's made in the skeleton that either these case management powers exist or they don't. They can't be cherry-picked to say, well, they can in respect of the type of order made by Deputy District Judge Openshaw, but not in respect to the type of case management order that we sought.
Well, that goes back to the questions that my Lord was putting to you. Effectively, your submission is that what DDJ Openshaw did was a form of case management that indirectly affected the protocol process. Your order was similar, it was just a bit more specific in relation to the protocol process.
Yes, and put stage 2 first.
Yes.
Specifically.
Yep.
The next point that's made by my learned friend over the page to page 82 is this issue about us not applying to lift the stay, which I think my Lord started questioning me about at the outset of the hearing. I briefly touched upon it. The reason why that application was abandoned was because of the indication that Judge Baldwin had given that if he did lift the stay, all he was going to do was transfer it to Part... Or all he could do was transfer it to Part 7, which would have exposed the insurer client immediately to jeopardy in terms of costs, which of course...
You'd be lifting a stay on a Part 8 claim, which is otherwise supposed to be a mere shell to enable the protocol to be complied with, despite the limitation period expiring.
Yeah. But his second reasoning or reasoning was once I've lifted. I mean, this comes back to the first instance arguments in Cable. So that before this court considered Cable, the argument was along the lines of, well, once the stay is lifted, the claim is in some sort of legal limbo, and it's an act of mercy then to strike it out, as it was in Cable, which of course was found to be the wrong approach by this court. So what Judge Baldwin is saying, well, once I've lifted the stay, I've got to do something with it, and the only thing I can do with it is transfer it to Part 7. Whereas what we were saying was you can lift the stay and you can make a case management direction in the Part 8 proceedings in the form in which we seek. But my learned friend's argument is this is a bar to this appeal because we didn't in fact lift the stay and therefore he couldn't make a case management direction. But those, as we've said, stand and fall together because we only withdrew that because he'd indicated that...
Let me see if I follow this. You lift the stay so that the case management direction of the kind you were seeking could have been made. So, when the original order was made, it imposed a stay.
Yes.
You're only applying to lift so you can make a further order of a similar nature. But the expectation is that the PAP process will continue.
Yes.
And indeed, that's why I was asking, if you lift the stay I'm trying to see how it makes sense. If you lift the stay in that context, on your application, theoretically, the Part 8 claim could carry on, but because it's a shell procedure, most of the Part 8 rules are disapplied. Nothing will happen. In other words, lifting the stay serves no purpose on your type of application, save to make a further direction affecting the conduct of the PAP process. Have I followed?
Yeah. So save to avoid an argument that, for example, if the judge just left it stayed, there's then an argument as to whether or not following grant, as we touched on the outset, there is a power then to actually case manage because the stay operates to pause all time limits. So
well, unless you lifted the stay, assuming you have a case management power, you couldn't exercise it. I thought that's what you said earlier on.
I'm sorry, my lord?
Unless you lift the stay, you couldn't exercise any case management power you otherwise have.
That would be my interpretation of the position. Because otherwise, the stay operates as a sort of procedural bar on time limits. And it certainly would give rise to potentially to an argument that if the claimant breached the unless order, they would say, well, there's a stay, so the unless order date hasn't yet.
Oh, I see what you mean. Yeah.
Because it stayed.
Yeah.
I think I've dealt with, as we've gone through all of the other points on page 83 in the respondent's notice.
Well, at the moment you're just dealing with the jurisdiction point. So if there's any points on the points in the respondent's notice, you have we'll give you the right to respond on those. But at the moment we're just focusing on whether the court had the jurisdiction to make an order that had, whether it was a direct or an indirect effect on the PAP in the manner that you sought in Lim 2. And you've explained that Lim 1 was only designed to ensure that you could then have Lim 2, which is why you said they stood and fell together.
Yes.
Yeah. So is there anything else on jurisdiction?
No, I don't think so, my lord, unless I can assist you any further with any specific questions.
All right, no, that's very clear. Thank you very much.
Thank you.
Yes, Mr. Turner, so you're going to respond on the jurisdiction point and then make any points that you want on the respondent's notice points, which include the academic point.
Yes. So, my lord, the starting point is to recognise that these low-value claims pre-action protocol procedures are quite unique. They are not like other pre-action protocols. They are very carefully structured. They are self-contained, and they are quite prescriptive. And that is all done and justified by cost, proportionality, the intention and hope of reducing friction between adversarial parties, and, of course, saving court time. So we have carefully structured regime, and the situation we had here was an application for a stay granted entirely in accordance with the structure of that regime. And, my lord, it's important to actually look at the pre-action protocol itself and then the practice direction to see how it differs from the standard situation you might have where a party comes to court looking for an indulgence from the court, a stay in its favour. So
the parties have come to court because there was the Part 8 claim.
Yes.
I mean, it's agreed between you that absent the Part 8 claim, the court would not have jurisdiction to get involved in the PAP.
Absolutely.
The question is whether once there's a Part 8 claim, the court does have the jurisdiction to make the sort of order that the defendant sought here.
It is,
That's
Lord,
the
yes. And the point I am making is that the stays which are granted pursuant to the protocol procedure for low-value claims differ from the stays which might ordinarily be granted in a case management situation in relation to an extant claim which is up and running. So if we look at tab 14 of the authorities bundle, we're at paragraph 5.7 of the protocol, page 320.
Could you give page references? We don't have, at least I don't have.
Page 320, my lord.
Thank you.
Yeah.
And the limitation period provisions quite specific at 5.7 and 5.8. And it's 5.7 of particular relevance here. It mandates that the Part 8B, now 49F procedure has to be used.
Mm-hmm.
And that procedure appears at tab 13, and page reference for paragraphs 16.1 to 16F is 311.
Yeah.
And so 16.1 limitation, introductory paragraph, 16.2, the claimant must start proceedings under this practice direction and state on the claim form that claims for damages and a stay of proceedings is sought in order to comply with the relevant period. So absolute minimal requirements in relation to what needs to be stated on the claim form. And then at 16.3, the claimant must send to the defendant the claim form together with the order imposing the stay. So note there that this is not like an ordinary stay where an application would be issued, the defendant would potentially object, there would be a hearing.
It's an ex parte stay.
It's an ex parte stay. The defendant isn't involved at all until the defendant is effectively given a fait accompli. We've applied for a stay, we have a stay. And then at 16.4, this applies various sections of the practice direction once that stay is imposed. 16.5 sets out, and 16.6 set out the options, what's to happen when the stay comes to an end. Now, your lordship actually dealt with the distinction between this procedure in terms of a stay and the general procedure in Cable at paragraph 14.
What the practice direction doesn't do is to say how long the stay should last for.
That's right.
It's left to the judge to
It's left to the
exercise
judge.
discretion.
My lord, yes, and there appears to be a standard practice, my learned friend will correct me if I'm wrong, of granting a 12-month stay. It appears to be the standard practice in the county courts, so far as I think both counsel are aware. Certainly in Liverpool. So if we look at Cable, it's page 3 of the authorities one. You look at paragraph 14 on page 6. And if I can invite the bench to read paragraph 14.
Yeah, that's the ex-parte point.
Yes, the point is it's unique. And the reason for that, and the point's made again, paragraph 78, that it's a distinction arising from cost and proportionality considerations. The PI protocol is very different from the RTA protocol. It requires a completely open approach in respect of medical treatments, experts and rehabilitation, none of which is reflected for obvious reasons of proportionality in the RTA protocol. So we have a very specific and unique procedure.
Yeah.
And it's essentially administrative. A request is made on a claim form without any detail. No evidence in support is required. There need be no justification beyond saying we haven't been able to complete the protocol, we therefore request a stay. And crucially, there is no involvement of the defendant at all.
Yeah.
So that needs to be justified. And of course, the justification is that this scheme is about bulk litigation.
Yeah.
It's about cost effectiveness. It's about dealing with cases with a minimum of friction at a proportionate and reasonable cost given the modest sums involved. These are all going to be low value claims. And importantly, by structuring it in that way, the architects of the scheme have avoided the need, quite deliberately in my submission, for active judicial consideration of the merits of the stay at this stage. So the whole structure is intended to keep the courts out of it effectively, whilst the parties have a chance to sort things out before they need.
Well, not
trouble
quite,
court.
because the claimant is seeking the assistance of the court. But that happens by reference to what my lord called a shell
Yes,
Part 8 claim.
it's
But the claimant still needs the assistance of the court, otherwise the claim statute bar.
yes, but it's
So-
effectively a device, an administrative step to stop the claim becoming statute barred. But the important point is it doesn't require active judicial consideration of the merits or otherwise.
Well, not the merits
stay.
of the claim, because there's no need for a judge at that stage to consider the merits of the claim. There would be a need potentially to consider the merits of the claim as and when the liberty to apply provision is triggered.
My lord, there's also no consideration of the merits of the stay as to whether the claimant is justified in seeking or obtaining a stay. That's the point. It's effectively an administrative exercise. And we can see that from the minimal requirements that we have in the claim form and that are required in the claim form. And the whole point of that is so that district judges up and down the country don't have their days taken up looking at whether or not it would be meritorious to grant a stay in relation to these low-value claims. And to avoid the need for any perhaps change in primary legislation in relation to the limitation period, you have this procedure which protects the claimant's position whilst the protocol procedure is exhausted.
Does that mean that ordinarily there wouldn't be much point in making an application within 7 days to set aside the stay for the reasons you've just given?
My submission would be that's not something which would be encouraged or should be encouraged, because it would to a large extent defeat the structure of the scheme. But it would be open to a defendant when they receive, in an egregious case, to say, we are now 2 years and 11 months or 3 years effectively from the date of the accident. We had the claim notification form. We have written 50 letters and had no response. 12 months is too long against that background. The court should, if the court is to to grant a stay, grant one for a reduced period, or the court should refuse a stay in the circumstances. At that point, then there could be an argument as to whether or not a stay would be justified. But absent that, and that's why you have that 7-day.
So the circumstances of this case were such as to, on your argument, as to potentially make it appropriate for such an application to have been made?
No.
Otherwise it's a hollow point.
That's descending into the facts, on the facts of the case.
But you're actually, I thought you were advancing, you're saying that's what the insurers could have done in this case. Well, they could, on your argument, they could only have done that if there was a reasonable prospect of getting the court to go against the normal practice.
My lord, yes, we're at cross purposes. I'm saying they could have done that.
Yes.
That option was open to them, but I'm saying on the merits of the case, they shouldn't have done that because of the facts of the individual case. But the point is that is an option that's open to them. But the key point here is that this is, as it was said in by Lord Justice Jackson in a case some time ago, Phillips and Willis, that it's fairly rough justice, this procedure. The procedure will fit precisely with some cases. It won't fit so well with others. But overall, it achieves the aim.
And the aim is compliance with the protocol.
Yes, but the aim is also compliance with the protocol, reducing friction, reducing costs, reducing unnecessary involvement of the court.
By complying with the protocol.
Yes.
So the rough justice, all of your submissions are all based on the premise that you comply with the protocol.
Yes. But this case isn't about whether someone did or didn't comply with the protocol.
Well,
because
that depends. Anyway, that's all of this. The protocol is the heart of it.
Yes.
Complying with that.
And so what we have is a procedure which is prescribed, which was followed to the letter here. The claim form is at tab 2.1. It's not. That's not. I needn't take the floor to it. Of course, seen it. It complies with all the requirements. An order is made by the court giving a seemingly standard in Liverpool 12-month endorsed stay with the standard endorsement as to any party wishing to apply to vary or set aside this order may apply. And I've made the point that that option's there, and it is an option that would be open to an aggrieved defendant to say you shouldn't have imposed a stay, you should have shortened the stay. And with that option there, the court then doesn't need to start importing case management powers for extant litigation back into the protocol process. There's just no need for it.
It's that leap that I don't follow.
Yeah.
Because if a defendant is aggrieved that it is not getting the communication from the claimant, and the defendant receives an order saying the court has imposed a stay, and you have 7 days to challenge, and the claimant has another 12 months on that stay, the defendant could, I'm not saying the defendant should, but the defendant could then use that 7-day clause to say to the court, we wish to have a hearing in relation to this stay.
Okay.
Because it is not justified because of reasons X, Y, and Z.
Well, that eventually happened sometime down the line, the following July, I think.
No, there was a difference in that they didn't just apply to alter the period of the stay. They applied for steps beyond that.
Yeah, they sought effectively to lift the stay so as to get the claimant to comply with the protocol.
Yes, so as to compel service of the Stage 2 settlement pack.
To comply with the protocol.
Yes, within 21 days, yeah.
That's the time.
That's what they sought.
But
yes.
That's what they sought. They sought to get the claimant to comply with the protocol, which is the aim of this whole process, compliance with the protocol.
Yes, but you don't need, and the court has no power to make the order that the defendant...
Sorry, can I ask a question?
Yes.
Let's look at it on the basis of your submission. There could have been an application to set aside the order made by the Deputy District Judge or to vary it. And you instance the possibility of substituting a shorter period for the stay as opposed to the standard practice of 12 months. If that had been done, say 6 months had been imposed, that would have been for the purposes my Lord's just put it, for securing compliance with the protocol. No other reason.
Yes, but
there would have been an argument between the parties as to how long is it going to take for the protocol to be completed.
Yes, but that is
and that's
question.
That's a case management
order,
isn't it?
It goes too far because applying to shorten the stay is applying to shorten a stay which has been imposed in respect of the Part 8 claim. That's all it does. Now, what the parties then do with that stay, of course, the understanding would be that it would be used to comply with the protocol.
Where does the power come from?
To shorten the stay.
I mean, you could say it's 355.
No, the power in relation to shortening the stay comes because the protocol does not impose any specific time in relation to the duration of a limitation stay.
I could ask my question another way. If a judge is going to select a period of 12 months, or alternatively vary that subsequently on application to 6, where does that power come from?
That power comes from the provisions in the practice direction and the protocol.
The practice direction doesn't specify a period, nor does it have a provision allowing for that period to be altered. It must come from the CPR.
No, but once an order is made, the party not present when the order is made has a right to have that order set aside. 23.10.
Does they have the right to have it truncated, though?
Well, it's varied. It's set aside or varied, I think, is the wording of 23.10. So what the party making the application would be doing there is varying an order on the basis that we didn't get a chance to make our arguments. So the court then starts with a clean piece of paper.
Yeah.
It's not varying an order.
Would be, well, they don't need more time to comply with the protocol because they've already had however long it is, 2 years, and therefore the stay should be reduced to 3 months.
That could be argued, yes, but the power to do that would simply be on the basis that the court has made an order in the absence of a party, and so the party has a right to be heard under 23.10.
Yes.
But the power to make the order in the first place comes from the practice direction.
Which must come, therefore, from the CPR.
Yes, in relation to that.
So there is power to make orders which have an effect on the protocol process.
An indirect effect, yes. The power to mandate or choose the period of the stay is a power that the court has. That is the power that the court has. And my submission is it goes no further than that, and that is a stay in relation to the Part 8 procedure. Very different to mandating a step to be taken under the protocol process, which is what the defendants invited the court to do.
But this is a jurisdiction point. So at the moment, I'm speaking for myself, I need to understand why there's a difference between the court having the power, as is accepted, to make case management orders which would have an indirect effect on the PAT process, but no jurisdiction to make a direct order that has an effect on the PAT process.
Well,
It's a very, to my ears at any rate, it's a rather odd distinction.
the answer to that is, firstly, the power is limited. It is limited in relation to the stay, not a general case management power under 3.12M that's being exercised. The power to impose the stay comes from the practice direction. Any application to vary the stay would really be a fresh application, not about the length of time the stay should endure. That's within the realms of the application that is permitted under the practice direction, the application for a stay. And secondly, there is a fundamental difference between making an order in relation to a stay of the Part 8 proceedings and making an order compelling a step within the pre-action protocol, which is not part of the Part 8 proceedings.
Well, the first part of the deputy district judge's order said that the stay would be lifted unless the parties proceeded to a stage 3 hearing under what was then PD 8B, and as Sir Dwyer confirmed a moment ago, that's a part of the process, the protocol, isn't it?
It's effectively indicating what is going to happen when the stay expires. Now, there is another option.
But what it presupposes is you've done everything under the protocol, including gone through stage 2. You haven't been able to reach an agreement. So the next thing will be stage 3, as defined by the protocol, which will be the assessment of damages. On
Yes.
paper, apparently.
Which is at page 312, paragraph 16.5 of the practice direction. So that order is essentially setting out the options specified under the practice direction.
Yes, but so you've moved on that basis to something which is happening in the Part 8 claims, I think you were told a moment ago, pursuant, as you say, to the practice direction. But it still presupposes that you will have complied with all the component parts of the PAT up until that stage. So it hasn't set out a timetable for each component part, but nonetheless it's saying it's all got to be done within the 12 months.
My Lord, that's 16.5, where the stay is granted by the court. The parties have complied with the relevant protocols, so
Exactly.
that's stage 1 and 2.
Exactly. That's the point I'm putting to you. So it hasn't actually laid down a timetable for doing each component part of stage 1 and stage 2, but it's saying you've got to have done all of it, without being more precise as to each element, within the 12 months.
Yes, it does it by reference to the stay.
Otherwise, unless it's converted into a Part 7 claim, it's going to be struck out.
Yes, but it does it by reference to the stay, not by compelling.
So it's an indirect effect.
It's an indirect effect, but the imposition of any stay with a deadline has an indirect effect, because in any context where someone obtains a stay, they are under direct or indirect pressure to comply with that stay. And to perform whatever they need to perform within the time allowed by the stay. So it's doing no more than setting out the effects or the options for the future, put it that way, as are consistent with 16.5 and 16.6 of the practice direction.
Okay.
So, my Lord, the stay was imposed here on the 13th of September of 2022 and in place for 12 months. This application was made 9 months into the stay, 5th of June. And it was dismissed for two reasons. And one of them, of course, was firstly that the defendants hadn't applied to lift the stay. And it, of course, is an insurmountable difficulty for the defendants that you can't make a case management order in a case that is stayed. And, my Lord, that's actually Grant and Dawn meets, which is...
But they complied, they sought to lift the stay for the purposes of that limb 1 in order to have the order under limb 2.
Yes, but then they withdrew from that.
Well, they then explained why those two things went together.
My Lord, it's not a major point if we're here to argue the jurisdictional point, but strictly speaking, you would have to lift the stay before you make case management order, which is the point made in the skeleton argument. So, my Lord, if we look at then this specific application which was made, that the claimant be compelled to serve its stage 2 settlement pack within 21 days.
Yeah.
We are at, I'll just get a page number for the relevant part of the protocol. It's at page 328. Of the, sorry, it's not the authorities bundle. Yes, it is. It's the authorities bundle, 328.
Thank you.
7.32, is it?
Should be an extract from the white book submitting the stage 2 settlement pack to the defendant.
Yeah.
And you have at 7.32 what the stage 2 settlement pack must comprise.
Yeah.
So the stage 2 settlement pack form, I'll take the court to that in a moment because it specifies monetary offers effectively. Medical reports, evidence of pecuniary losses. And then at 7.33, the claimant should send the stage 2 settlement pack to the defendant within 15 days of the claimant approving the final medical report and agreeing to rely on the prognosis in that report.
Yeah.
And the stage 2 settlement pack, to give the court an indication of what that entails, is at page 217 of the main book. Tab 3.1 if the main bundle is tabbed.
Yeah.
And at page 218, the court will see how it works. The heads of loss are identified. The evidence attached. There's a tick if evidence is attached. Comments, the gross value claimed, any contribution negligence reduction. And so the claimant is saying at that point, this is what I will accept for my claim. They're monetary offers that are being made in respect to the heads of loss.
This is on the second page.
Yes, page 218.
Yeah.
And then the defendant will, effectively on the right-hand column, accept or counter-offer
Yeah.
in relation to that. And the difficulty with making an order compelling the claimant to
The
serve
claimant was already compelled. The claimant was always obliged to provide this document.
yes, under the terms of the protocol,
Yes.
without court involvement.
Yeah,
So there is no...
Fine, but the claimant was always compelled to provide this document.
Yes.
So I don't follow any of the points that are taken about compelling him to do something. It's not compelling him to do something he didn't otherwise have to do. He had to do this.
Well, that's in relation to the timing.
Fine. That's in relation to the timing. So that's in relation to the 21 days.
Yes, but that doesn't alter the
Got nothing
point.
to do with the jurisdiction.
But the claimant has a stay. The claimant is operating within that stay. The whole structure...
That begs the question, what would have happened if the document you've just taken us to hadn't been created by the end of the stay?
Then there would have been an application to extend the stay, which is what happened in this case. There were several extensions of the stay due to the uncertain medical position.
But at each stage, the court is controlling the process for the purposes of enabling the protocol to be complied with.
The court is controlling the stay, and when you get to the end of the stay, at that point, the claimant would have to justify an extension to the stay. We're dealing with this first
Why
stay
shouldn't the
here.
claimant have to justify an extension after the stay's been granted if it was thought that stay was too long and you apply to lift the stay? You say they've had long enough.
If the defendants made that 7-day application, at that point there would be a contested hearing
Yeah.
as to the
We're
length
talking
of the
about his
stay.
jurisdiction.
Barred from making it after the 7 days.
No, you could make an application after the 7 days in the way that you can make any application in relation to issued proceedings, but you would then need to justify why you didn't make the application within 7 days. The difficulty, my lord, with the application coming within this stay and requiring the claimant to, on that process where an application is made to justify the position within the stay, is that it undermines the cost effectiveness of the protocol, which is to keep the court out of it. That's the whole intention.
But how can that possibly be right in circumstances where there is effectively a position where there wasn't even a medical examination until after the limitation period had expired?
Yes, that is justified and explained in the witness statement, which was filed in support of the application.
Well, speaking
but that's
for
a separate
myself,
question.
It's not justified or explained. It is the thinnest possible excuse for delay of the COVID at my homework type. So had it been a matter of discretion, speaking entirely for myself, I wouldn't have given the claimant any sort of stay at all. So there is no justification, in my view, for the delay. And so to say that it spoils the cost effectiveness of the protocol process by getting the judge simply to say, well, look, you've had long enough. I'm going to curtail your time for putting this pack together, so you've got to get on with it. To say that that spoils the cost effectiveness in a case where the claimant has delayed for so long is just a non-starter, Mr. Turner.
Well, leaving the facts of this case aside, we're looking at it from a jurisdictional point of view.
Yes.
The protocol has been structured to give this stay. And if the claimant follows that process, the point is that that can happen effectively as an administrative step without the defendant being given notice of the application.
But without relieving the claimant of the underlying obligation to comply with the protocol.
But that
It's not an excuse for endless delay. That's contrary to the protocol.
My lord, this is not a case of endless delay, but that's descending into the merits of this particular, the facts of this particular case.
Jurisdictionally, the overriding obligation on the part of the claimant at all times was to comply with the protocol.
Yes, of
Yes, he had there were various things that the process gave him, like the ability to issue protective proceedings under Part 8. But none of that detracted from his overriding obligation.
But the application or the issue of the Part 8 proceedings was in accordance with the protocol.
Yeah.
The granting of the stay was in accordance with the protocol. The claimant was then operating in accordance with a 12-month stay that had been granted by the court.
But he wasn't operating within that because he hadn't had a medical examination until the following year.
Well, my lord, the claimant was operating, whether the claimant was operating as timiously and promptly as the claimant could have, that would be a matter for the discretionary point and the discretionary argument. But in terms of whether the court should be getting involved when the procedure has been followed and a stay has been requested in accordance with the protocol, a stay has been granted in accordance with the protocol, it really would drive a coach and horses potentially, should these applications become common from defendants, through the intention of the protocol, which is to keep the courts out of it. Because how many of these applications would be made? There would then have to be active consideration of whether or not a stay is justified.
I know, all terribly regrettable. And a matter for us is going to be why this case is in that position. I agree, the last thing we want is overworked district judges having to deal with recalcitrant claimants and delays under the protocol. They've got enough to do. The whole point of the protocol is that people are supposed to get on with it.
My lord, it is. And here, we were 3 months away from the end of the stay. If the claimant wanted an extension to that stay, the claimant at that point would have had to justify that by way of evidence in the same way that you would have to justify a stay outside of the protocol process. Because effectively the claimants had the indulgence of that first stay. And things change at that point.
So does it really boil down to the fact that the protocol assumes that you'll get 12 months, and once you've got 12 months, well, that's just tough luck as far as the defendants are concerned. They can do what they like. They can sit on their hands or they can actually do something. Is that really what it boils down to?
Well, no, because the defendant could, in an appropriate case, apply to say this order was made without any input from me under 23.10.
Within 7 days.
Within 7 days, or they could make an application later to shorten the stay. But that's an application in relation to the Part 8 proceedings. It's not an application compelling a step to be taken under the protocol, although I take His Lordship's point that, of course, claimants are always under a duty to comply with the protocol, as are both parties. But there is a procedure here. The procedure was followed. And if the claimant didn't follow that procedure, then there are remedies for a defendant in that position because they have abuse of process arguments. They have the argument under was CPR 45.24, now 45.35, which is the claimant should be penalised in costs for removing the case from the protocol and failing to comply with the protocol. There's the general provision in CPR 3 that the court will take into account compliance with protocols. CPR 44, the court is to take into account compliance with protocols everywhere in the rules. Compliance with protocols is signalled as an important factor. There are remedies for the defendant that do not involve importing general case management powers at stages of the protocol where those who designed the protocol did not expect the court to be involved in anything other than an administrative capacity. And this,
But the court would be involved in something other than an administrative capacity, even on your case, if they were truncating the stay.
yes, my lady, my case is not that they should truncate the stay. What I'm saying, that option is there.
Powers. Yes, but the minute you accept that there is such a power, inevitably, to a limited extent, the court is getting involved.
Yes, it's getting involved with the Part 8 claim and the duration of the stay. And that is because the protocol does not dictate any mandatory or recommended time. There's nothing to indicate what the duration of the stay should be. And that could have been done.
The court normally has powers, does it not, to make stays conditional?
In relation to,
If you're going to grant a stay, it's a discretionary power. It's not mandatory to grant it. You can grant a stay on terms.
well, lady, that's where the distinction between these low-value protocols and other claims under their protocols becomes absolutely fundamental. Because the claim form...
You say that under these protocols there is no power to grant a stay on terms. Is that it?
Difficult to make such a broad concession on the hoof, but certainly no power to impose such a condition that obliges compliance with a step in the protocol.
Well, I'm just talking at the moment in the abstract about the case management powers of the court under the protocol or in relation to the Part 8 claim. Given that you've got powers in relation to a Part 8 claim, there are peculiarities about this protocol because the Part 8 claim isn't the usual species, and the rules actually specifically dispense with a lot of the usual things that go attached to a Part 8 claim, like the obligation to serve evidence and so on and so forth. So all of that's dispensed with. It's simply a vehicle for preserving limitation period to make sure that the claimant isn't disadvantaged. That doesn't stop it being a Part 8 claim to which there are powers in relation to the granting of a stay. And at the moment I'm scratching my head, metaphorically, trying to work out on what basis it can be said that the power to grant a stay, which you're both agreed there is, can't be made conditional.
Well, the power comes from the Practice Direction 49F, page 312.
Yeah.
And there is nothing there, and it would have been easy for the draftsman to include a line within the practice direction saying the court may impose a stay on such terms as the court thinks fit.
Does it really need to? I mean,
As a former drafter of the rules, we try not to. If we're saying the court has the power to grant a stay, the implication would be the usual powers, rights, qualifications would go with it.
yeah.
Well, also you'd have to read this in conjunction with the case management powers in 3.1 of the CPR, 3.12. This is page 130 of the Bundle of Authorities. Subparagraph F gives a power to grant a stay of the whole or part of any proceedings, generally until a specified date or event. And then you're reminding us that in the same rule, 3.14, where the court gives directions, it can take into account whether or not a party has complied with a PAT.
Yes.
So if you can take it into account, presumably you can make a case management direction which reflects the PAP in some way, directly or indirectly.
The difficulty with importing it is that we have this structured scheme whereby we have an administrative Part 8 claim, a shell, I believe was your lordship's phrase. That's all it is.
Yeah, but the trouble is, once you get, for example, to the end of the first year of the stay, and there's an argument about what's going to happen next, and has enough been done to comply with the protocol. Is the court actually toothless to do, in the sense that it can't do anything more than grant a stay for a period of time or refuse any further stay? Are those the only choices available to it?
At that point, well, effectively what the court does is lift the stay and transfer the claim to Part 7. That's what would
That's
happen in
not
those
promoting
circumstances.
compliance with the protocol, though, is it?
No.
No,
it's
and
the antithesis.
Promoting litigation.
Yes, and the claimant is penalised for that in costs under CPR
Well, so potentially is also
45.35.
the defendant. It's a different cost regime for both sides.
Well, Lord, the difficulty...
I mean, and all of this is actually working against trying to encourage people to comply with the protocol.
The difficulty with importing considerations as to merit into that initial stay is that the advantages of it being a purely administrative step are lost. The loss in terms of judicial time in considering merits, costs, there's the adversarial element to it, and that is a significant would be a significant disruption
Well, maybe
of the
a
scheme.
distinction needs to be drawn between whether the court has any jurisdiction at all, is completely unable to do something which intrudes upon the protocol, as opposed to if it does have the power, in what circumstances should it use it?
Yeah.
Maybe only in very exceptional cases or egregious cases, for the very reason you've just given.
Well, my lord, that of course is an option for the court, but my submission is when you look at the prescriptive elements in 16.5, 16.6, 16.7 is there as well on page 312, there is an inexorable character to the protocol, and that is this happens, then this happens, then this happens. And where there is delay, the point at which the court becomes involved, frankly, should be as late as possible. And the way that is achieved is by having this administrative mechanism in relation to the limitation stay. With the
slight difficulty with that is that the claimant, there's a danger of the claimant in those circumstances having its cake and eating it.
Yeah.
Because if you say the court's involvement should be as late as possible, as you put it, the court is only involved because the claimant needs its protection in the first place because of the delay and hasn't issued a claim within the limitation period. So the claimant is seeking the indulgence of the court by the Part 8 process. And then you say, and then it should have the second indulgence of the court not getting involved in the detail until as late as possible.
Well, my lord, it's not an indulgence, it's what the protocol says. The stay is granted.
It is an indulgence. It is an indulgence because it's covered by the protocol. But it's covered by the protocol in circumstances where a claim has not been issued within the limitation period.
Fine.
My lord, it's an indulgence then, if I could put it this way, which is built into and part of the design of the protocol.
Yeah.
I don't see anything in these rules which mandates the court to grant the stay that's applied for. In fact, quite the contrary, 16.51 talks about where a stay is granted by the court. In other words, it preserves the ability of the court to say, no, I'm not going to allow you to have a stay of your Part 8 claim. You can start your Part 8 claim because I can't stop you from doing that, but I'm not going to grant you a stay. And if the court can say, I'm not going to grant you a stay, then it is actually getting involved in more than a rubber stamping exercise.
Well, my lady, in that regard, it is implicit that the stay will be granted because
And
there
in
is...
most cases, it probably would be.
Well, with respect, in all cases, because the claimant has not made has not provided any justification for a stay beyond we have been unable to complete the protocol, because that is all the claimant is required to state under the scheme in the claim form. So there could be no basis on that material that the court could refuse the stay because the court only has the bare minimum because it's an administrative step.
Okay, well, we have that submission. On this question of jurisdiction, can I just ask you about this? Do you have the white book there?
I have an electronic copy.
It's page, volume 1, it's page 2647.
The download from Westlaw stops at 2638. Is it practice direction?
It is.
I have that as a separate.
Yes, it's the section C, practice directions, pre-action conduct and protocols. I'm sorry. Section C is pre-action conduct and protocols. They're all together.
Yes, I'm just getting it now. Could I have the page reference again, my lord?
2647.
Yes.
And the first of these is practice direction, pre-action conduct and protocols.
Yes.
Yeah. If you go on in that to paragraph 13 on page 2648, there's a section called compliance with this practice direction and the protocols. You see that starting
Yes.
at paragraph 13. Paragraph 15 says this: where there's been non-compliance with the pre-action protocol or this practice direction, the court may order that B, the proceedings are stayed while particular steps are taken to comply with the pre-action protocol. So it might be said that that's precisely what limb 2 of the order was seeking to do.
That's in relation to the pre-action protocols generally.
Yes.
And the whole point of this, as your lordship said in Cable, is this is a different procedure.
Well, I said that in general terms because it plainly is. But there's nothing that disapplies that provision in this procedure that, so far at any rate, that we've been shown.
No, there is nothing specific, or that is correct.
Well, just for completeness, paragraph 2 says this practice direction applies to disputes where no pre-action protocol applies. But when you go to 13, if a dispute precedes litigation, the court will expect the parties to comply with the relevant pre-action protocol or this practice direction. And then if you read on, then again, 15, where there's been non-compliance with a pre-action protocol or the practice, then, as my lord has pointed out, the parties can be relieved of the obligation to further comply with the pre-action protocol and has a power to impose sanctions as well. So this part of the PD applies where you do have a pre-action protocol, such as the low value one. And it's saying the court can exercise, on the face of it, case management powers.
I would come back to the point about the need for this specific process to be preserved and insulated.
But just going back to the submission you were making about a Part A claim made where the limitation period is about to expire, PAP hasn't been complied with. It may be the parties are only a short way away from completing the process. But there may be other cases where they're a long way away because the claimant's done nothing or very little. In that sort of situation, you would expect indulgence, to which reference has been made, to result in very vigorous action being taken by a claimant. And I'm just wondering where the system gets to if you have to wait for a year, the standard year, to see what happens, and then the remedy is to refuse to extend the stay so that the Part 8 claim comes to an end, and the only option the claimant then has is to start a Part 7 claim and apply under Section 33. And that's a rather extreme way of asking the court to manage the processes before it, rather than a more nuanced approach, a spectrum which allows for case management to take place before you get to those last-ditch scenarios.
But the difficulty is it imports consideration of the merits of the stay into a much earlier stage in the process.
Well, if the court were to encourage that, I can see that. But it's a choice between the court having only limited powers available to it. For example, a year after the stay was first imposed, and it's thinking of refusing to extend the stay. Well, I'm repeating myself. But that seems to me, speaking for myself, the sort of choice which is being presented.
Well, I come back to the self-contained nature of the scheme, and I've made that point. But I would also, even if you take that general power there, then go back to the specific direction which was being sought, and how unjust that would be if the court had a power to do that. When you look at the protocol, and you see that the Stage 2 settlement pack can only be disclosed once the claimant has accepted it. My Lord, you took me to the White Book, page 2795. This is actually a useful summary of the stages of the protocol.
Yes.
It appears in the notes after the ELPL, Employers' Liability, Public Liability Protocol, but of course the mechanisms and principles are the same. And you'll see the 15-0042 summary of Stage 1 and Stage 2 of the protocol. You'll see 3 paragraphs from the end. The Stage 2 settlement pack must not be submitted until the claimant has approved the final medical report and agreed to rely on the prognosis and approved any non-medical report. And the order was effectively compelling the claimant, the order sought was compelling the claimant to disclose his medical evidence before he had reached that final stage.
So that was an argument about the timing. Because the argument would have been, well, we can't do that in 21 days because of this and that and the other. And so the judge would have said, well, how long could you do? This is assuming there's jurisdiction to make the order. How long could you do? What are the stages that need to be gone through? And that would be identified, and a period would have been identified.
But that comes back to whether or not the court mandates a step in the protocol, or whether the court simply then adjusts the duration of the stay.
Well, okay, but we're now dealing with the, you keep saying compelled to provide a draft report. That's because of the 21 days.
Yes, but the point is this can be achieved, if it is to be achieved, by questioning the standard 12 months.
I follow that goes back to that argument. There's the indirect woolly way, or there's the making an order, you've got to do this by such and such a date. And then the argument just becomes about what that such and such a date is.
It does, but my Lord, I make the point again that all of this will import friction. Of court time, judicial involvement in stages.
Well, one hopes not, because one hopes that one doesn't get to a position whereby it's not commonplace for claimants not to have medical examinations until after their claim has expired. I mean, that's the slightly tart, but I think apposite answer. I agree, and I've said before in this hearing, and I should say again, the last thing I want to do is to ensure that district judges up and down the country are spending half their days making orders in PAPs with recalcitrant claimants. And you can rest assured that that general proposition will not be the outcome of this appeal. Is there anything else on the jurisdiction point? I know you've got your other points in the respondent's notice. We've slightly bled into those because you're now taking the point about compelling to comply with, to provide medical reports. Do you want to move on to those?
I could just...
You've touched on some of them already, I think.
Just looking at the notes I made whilst my learned friend was making his submissions. He made the submission, we've effectively covered this, but when considering the application, it comes down to how good is the explanation. That was his point. But my point there, of course, is that the protocol has been carefully structured to not require an explanation. By the defendants making such applications, the claimants will sit up and provide an explanation. Again, evidence will need to be provided, not within the scheme structure of the protocol. And the fact that the Part 8 claim form is no more than a device I've already made. So those are my submissions in relation to jurisdiction. I apologise if there's any repetition in there.
No.
In terms of the respondent's notice,
I mean, we have the point that on the facts as they fell out, 21 days would not have been long enough for the claimant properly to approve the constituent elements of the stage 2 settlement pack.
Yes. Your Lordship's indicated that the witness statement in support at tab 1.18 has already been read, so I actually didn't take the court to that. So what we have then is, with 3 months from the end of the stay when this is being heard, and the court, any court taking a view of the situation as it was at that point, given the impending end of the stay, would be unlikely to impose an unless order, because the court is going to be looking at this at the end of the stay in any event. The next point is that to go straight to an unless order, the nuclear weapon, effectively strike out, would be disproportionate, and the court wouldn't have gone to that stage. The court would merely have, in my submission, on a proportionate response, have ordered compliance with whatever direction the court saw fit. And there is an explanation provided in that witness statement, and it may not be, in your Lordship's view, as expressed, the strongest of explanations, but it nevertheless demonstrated that there was a claimant in that situation who would have needed time to comply. So if the court then had structured a timetable through to the end of stage 2, and the crucial point to recognise is that the stage 2 settlement pack comes at the end of stage 2, not at the beginning of stage 2.
Yeah.
So it's the end product of the process. And it's clear that...
Well, it's not the end product, is it? Because then the defendants have to respond.
Sorry, yes, the catalyst for the negotiation stage, but in terms of the claimant's presentation of his case, it is the end product. It's not the opening gambit.
No.
And the court would then have to allow for the offers, counter-offers, consideration periods, etc. And that all takes it past the end of the stay that would have been imposed in any event. So the application would have been dismissed for those reasons. It just wasn't necessary. The stay was coming to an end in any event. And the court could have looked at the merits then.
What would have happened then? So imagine this application had not been made and we got to the end of the process and there was still no stage 2 settlement pack.
Yes, the claimant would have had to apply to extend the stay. At that point, there would need to be a consideration of the merits as to whether or not to extend the stay.
Yeah.
And at that point, the court would adjudicate upon the differing positions. In fact, the stay was renewed several times here because the orthopaedic surgeon said he didn't know whether the claimant's symptoms were from underlying degenerative change or traumatic, and so he requested x-rays before giving a prognosis. The x-rays came and they were...
So is that what he was saying, according to the witness statement, that responded to the insurer's application? There were x-rays said to be necessary at that stage?
Yes. So in his first report, he said,
The one in May?
The one in May,
Yeah.
which was in draft form.
Yeah.
I can't say whether this is constitutional or traumatic. I need to see x-rays. What's subsequent?
3 months before the stay was coming to an end?
Yes, the timetable for obtaining that report is given in that witness statement.
Well, up to a point. I mean, we're told that the claimant didn't attend 2 appointments in 2010, and then we're told of the ill health of a particular expert, and then we jump to 2023.
I can do no more, my lord, than point the court to the witness statement.
But the original stay expired on the 16th of September 2023.
Yes.
The following month, your solicitors informed the defendants that the matter had exited the portal.
Yes.
So the stays have to be seen against that background. That he'd come out of the portal.
Yes. Now that was due to the claimant's solicitors serving an interim settlement pack, seeking an interim payment in relation to the cost of x-rays or perhaps an MRI.
But we don't need to worry about
point,
that, do we? Because District Judge Jenkinson said it was unreasonable.
Yes.
The exiting from the portal.
Yes, they'd gone too soon. They'd first sent the interim settlement pack without the medical evidence supporting it. They then came out calculating the relevant period from the date they'd submitted that interim settlement pack, but that was defective because it didn't attach the medical evidence. They served a replacement interim settlement pack with the medical evidence, and they took the claim from the portal, the protocol process, within the relevant period following the compliant interim settlement pack. And so they exited prematurely.
All right, so on the respondent's notice point, we have the 21 days point and the draft reports and so on.
And the strikeout point, it's too draconian. And
the nuclear option point.
yeah. And the fact that the stay was about to expire anyway. At that point, the court would be looking at this. So there'd be no need for the court to make an order at this stage. So, Lord, that then takes us to the question of whether or not this appeal is academic and whether the court should hear it. There's a kind of Kafkaesque element to arguing that the court shouldn't hear an appeal that we've just spent 2 hours arguing.
It is, Mr. Turner, and I'm sorry that we've come to that at the end, but the academic point, obviously, we welcome your submissions on it, Lady Justice Lang said that it would be dealt with as part of this hearing. So because the parties are geared up to argue and have argued the substantive points, it is slightly bizarre that we're then having an argument about it being academic, but I think that's just the way the cards have fallen. So there we are. I mean, I don't encourage you to spend 4 hours on this point.
Not going to be, my lord.
But do make your submissions.
Well, Lord, I'm going to start from the proposition that this is an academic appeal, because if you look what sought submission of the Stage 2 settlement pack, that simply can't happen. And so even if the order is set aside, that then raises the question, well, what then happens? Because if the application is not dismissed, it's allowed, or it sits there in limbo and has to be withdrawn, which is the equivalent of a dismissal. So I start with the proposition that when you seek compulsion for submission of a Stage 2 settlement pack, the claim then exits the protocol. The decision here will be, although it could conceivably be of wider value to other litigants, in terms of this claim as between these litigating parties, it is academic.
Well, I asked what would be the position with regard to the Part 8 claim, and you said it might be in limbo, but at page 207, there was an order made on 23rd of February last year, stay lifted, and the matter is transferred to Part 7. So the matter would be presumably the Part 8 claim.
I was talking about the application. If the decision on the application is set
and what
aside.
to do with the application, but then you also talked about the claim. But in fact, the claim has been transmuted into a Part 7 claim, isn't it?
My lord, that's one of the reasons why we submit this is an academic appeal. There's a trial window opening on the 30th of June. The matter is ready for trial. And so anything referable to the pre-action protocol.
But the reason why I draw attention to this is the dismissal of the application would be a mere formality. Doesn't really matter.
Yes, that's my point. It's an application in relation to a step in the protocol. Not only has the claim exited the protocol, it is far beyond anything pre-action, and it is in fact ready for trial, with the trial window opening on the 30th of June. My lord, the court has a discretion, of course, but that discretion between private individuals is to be exercised in exceptional circumstances, and my submission is there are threshold criteria which have to be fulfilled before the court even considers whether it ought to exceptionally hear an academic appeal. And tab 34 of the authorities bundle, I shall get a page reference, is Hutchison and Popdog.
Tab 34.
There isn't it?
Sorry, hold on.
Happily, there's only 14.
Yes, it's going to be a page, isn't it? Apologies.
That's all right. Is it page 34?
Probably.
Did you say
It's
Hutchison
Hutchison and Popdog. It's page 34, tab 3.
Yeah.
Apologies.
Well, these criteria get trotted out day in, day out in this courtroom. There's often a debate about what is meant by save in exceptional circumstances, but there is an ordinary requirement that it's going to be argued by both parties properly, that one party who's there reluctantly has got cost protection. There's an order that says we won't seek our costs against you if we win on the point which turns out to be academic, and so forth. But this court has recently, on more than one occasion, said, well, even in circumstances where those aren't satisfied, we're still going to entertain the appeal. And I know because I've sat there and done it.
Well, Lady, I accept that. Hutchison and Popdog does make the point that those 3 threshold criteria are there,
Yeah.
but even if met, the court has the discretion. If not met, of course the court has a discretion as to what it is. I'm not suggesting the court doesn't. It is a discretionary situation. But if you look at the 3 points within Hutchison and Popdog, point of general importance, well, it's conceded second appeal permission has been granted, but that was without full argument. And if we look at what's happened since then, indeed the position as it was then.
Can you remind me, did you put in a practice direction para 19 statement?
Yes, and we
You
did
did.
take the point that the appeal was academic. It's in the bundle.
Yeah.
Lady. Yes. So it was taken at that point. So, and the point that was made then and is made now is there is no evidence so far as the respondents are aware that this issue is causing problems within the courts and case management. Nothing from the Civil Justice Council or Rules Committee so far as the respondents are aware to say that this is an issue of importance. No interveners have come forward, but no articles have been cited, academic articles or anything to suggest that this is an area of significant dispute or even any dispute outside of this appeal. Forum chatter, your lordships will be aware these days there are many legal forums, nothing brought to the court's attention or the respondent's attention to suggest that there are people out there saying this really needs to be decided because this is a problem. And so the implication from that is that the current system is working well. The provisions, re-limitation stays are operating as intended. And essentially there is no wider point of general importance that the court needs to solve. So that's the first requirement, the point of general importance. Second requirement, the respondent agrees to the appeal proceeding or is provided with a complete indemnity as to costs. But that indemnity has been requested and refused. It has not been offered. And the respondents did not wish to be involved in an academic appeal. They are here in many ways against their will.
What weight should we attach to that factor, given that we are actually sitting in a substantive appeal hearing?
Because if the appeal's heard, the respondents are at risk.
The costs are being incurred by the IC.
We're at risk on costs. If
Yeah. That can only be dealt with by the court, subject to submissions considering no orders to costs. But the costs that you've incurred in any event.
Yes, and we're exposed to that. It seems for a point that the insurers standing behind in fact, I think the second defendant is an insurer in this case, they wish to have resolved. And so there is prejudice to the respondent by having to deal with a purely academic appeal. And the prejudice is in relation to costs. And the third requirement is that both sides will be fully argued, both positions fully aired. Well, they have been. I think we can say that. But of course, there's an irony here that the appellant criticises the respondent for not taking a neutral stance in relation to the appeal in the supplemental skeleton argument, which deals with the academic question, saying, well, it's been actively opposed. Well, the irony is that we have to actively oppose before the court will
Unless you de facto or in a micus, as it were.
So
the court wouldn't be determining an important point of principle without proper argument.
So we've in fact, ironically, done the
That might
appellant
go
a
back to
favour.
the second point in cost.
Yes, we've in fact done the appellant a favour by fully arguing the contrary position. Because
On this point, the claimant exited the portal by the time of the hearing in front of Judge Wood, but the point wasn't taken then that it was academic.
no, but it was taken in the 3-page response.
Yeah,
In
and the
relation to the
permission was
application for
granted.
permission.
And then subsequently the academic appeal point arose and Lady Justice Lang said that'll be dealt with at this hearing.
No, my lord, the academic appeal point was raised before permission was granted.
I understand it was in the statement, but the permission to appeal grants permission, and I think I'm right in saying doesn't refer to the academic point.
No.
Pages 4 and 5. And there was a subsequent order at which Lady Justice Lang said that the academic point would be dealt with at the main hearing.
Yes, as I recall the chronology, the academic point was raised in the letter objecting to permission being granted. When permission was granted, the respondent's skeleton argument then took the point on academic appeal, as the respondent was entitled to do.
Yes.
At that point, I believe there was a supplementary skeleton argument from the appellant dealing specifically with the academic appeal point.
Yeah.
And at that point, Lady Justice Lang gave her further direction, I believe, for the academic appeal point
so
to be heard today.
Sorry, so that's what I was putting to you, that's the chronology, that originally permission was granted on the face of it without any reference to the academic appeal point. And then there was a subsequent direction. You had raised the academic appeal point in your original response, but that's the chronology as far as the court is concerned, which is why we're here, because all of these, the pop dog guidance and all the rest of it, all rather presupposes that the academic appeal point will be dealt with in advance of a hearing in order to save the costs of the hearing.
Yes, my lord, that's one of the reasons why I say the court should make it clear that academic appeals of this nature are not to be heard. I've dealt with the three criteria in Hutchison and Popdog, and we don't have the indemnity as to costs, but the court, of course, could deal with that in relation to orders to ensure there was no injustice. But even exercising the, looking at the discretion after that, I would submit three reasons why the court should nevertheless decline to entertain this academic appeal. Firstly, it sets an unwelcome precedent. Secondly, it raises a question as to procedural efficacy. And thirdly, injustice to the respondent. So if I deal with them in turn, unwelcome precedent, well, it's a very high bar to a private law academic appeal. The threshold requirements, the three factors identified in Hutchison and Popdog are there. Even then, it's only a may, not a will. And to abandon those requirements once permission has been granted, and to say, well, effectively, once permission's granted, they effectively fall away, would be to effectively be too passive. It makes permission the key stage, and there isn't full argument at the permission stage.
But I think, again, it's become slightly unreal. Of the 3 points that from Popdog, if 1 and 3 were against you, it's only the cost point.
Yes. But I make the point in relation to procedural efficacy, because this, well, I'm looking at efficacy. I'm looking at whether it would be advantageous to the court to allow the way in which this academic appeal came before the court to become something which was effectively rubber stamped by the court. And the reason for that is that this appeal was an academic appeal. It must have been known by the appellants that they couldn't get an order for service of a stage 2 settlement pack. But in their notice of appeal, they did not alert the court to to that fact. The respondent did, but at that point, there's no scope for full argument. It's just a small section of a document which under the rules is no more than 3 pages. And what that means is we have here an academic appeal case which has effectively passed under the radar at the permission stage. So permission has been granted without there being full argument and full consideration of whether or not there should be an academic appeal.
But that's inevitable because of the way that permission is dealt with. I mean, you do get situations in which an appeal becomes academic after permission is granted, and then you get into pop dog, and there might be some kind of case management hearing. But in the normal run-of-the-mill situation, a single LJ gets the documents on the papers and has to make a decision as to whether the point is sufficiently arguable, etc. There is an opportunity for the respondent to put in a short statement, and that's all the court's got to go on. And at that stage, the judge granting permission or refusing permission has got to make up their mind as to whether the academic appeal point is so strong that they should refuse to allow the case to go any further for that reason alone, or whether it should progress to a hearing. And in this case, Lady Justice Lang went for the latter, because she thought, obviously, that it was a point that warranted passing the second appeals stage.
The second appeal stage is different from the academic appeal question.
Yes, I know, but in terms of the merits of the case, it's all bound up because you just don't let through an academic appeal at that stage if you think that you're going to be wasting court time.
Well, Lady, my point in relation to that is that a party making an academic appeal ought to alert the court opening clearly to that fact, and also set out why it is an academic appeal, so that the court has more to go on than a few lines in a cursory summary response from the respondent.
We have that point.
So the procedural point.
Mr. Turner, gripping how Kafkaesque this is, we ought to rise and come back at 2, if that's all right.
Oh, yes.
Thank you very much.
Court rises, people.